Hey guys, it's Anthony Bandiero here with Blue to Gold Law Enforcement Training. Want to do a really quick video about a U.S. Supreme Court case that's coming up. It's State of Kansas versus Charles Glover, and the Supreme Court is going to hear this case very soon. And the question is whether or not a police officer has reasonable suspicion to stop a car based purely off of the license check, the registration check shows that the registered owner has a revoked license. And I'm going to predict the future here for you, okay? The Supreme Court is going to say, yes, the officer had reasonable suspicion. The Kansas Supreme Court said the officer had a hunch. But really, is it a hunch when you know that the registered owner has a revoked license, and especially when there's only one registered owner, not two, makes it a little bit tougher case, but there's one registered owner, and you know from your training experience that most people drive their own cars. Is it possible that you can lend your car to somebody else and then the officer could have stopped your friend or your brother or sister? Absolutely. But that's not what reasonable suspicion requires. Reasonable suspicion requires the officer to articulate facts or circumstances that will lead a reasonable person to believe that criminal activity is afoot, right? The afoot is from Terry versus Ohio, but it's a fancy way of saying that you can put your finger on something. You can say, look, Judge, this is why I stopped this particular car. It wasn't a hunch. I believe that there's a good chance, a fair chance, at least reasonable suspicion standard, that the driver is the registered owner and therefore has that revoked license. A hunch would be, hey, I heard that a person driving a white Escalade has a revoked license. Oh, look, there's a white Escalade. Let me go stop that car. That's a hunch. You can't stop that car because you have nothing to put your finger on that this is a person driving a suspended license or revoked license. So the officer in Kansas, I think, did a great job. It is an important case. To me, it's an easy case. I don't know why it's taken the U.S. Supreme Court to get involved. I will say before I leave off, some teaching points here is that this maybe could have been avoided if the officer put in some more facts and circumstances. For example, that if the revoked license is for a male, that he believed that a male was driving. It didn't appear to be a female. Maybe the same age. If there's dark tinted windows, put that in there. Hey, look, I couldn't even see the driver because the tinted windows was so dark, right? That would have helped. The officer, from my understanding, purely stopped the vehicle and the report say, hey, look, registered owner has a revoked license, therefore I can automatically stop the car. It's probably true. I think, again, the Supreme Court is going to, I believe, find in favor of the officer, but it's always good to put those extra things in there, things that, clearly the officer probably had more information. He probably saw a driver that was male, or, for example. So I hope that helps. I just want to throw that out there. If you want me to answer more of your search and seizure questions, contact me through the bluetogold.com webpage. Also, if you're interested in having me come out to your agency and teach you and your fellow brothers and sisters advanced search and seizure law, do the same thing and contact me. Be safe until next time.